Hello?
Hello, is that Mr. Hussain?
It is, yes.
Hello, it's Sian calling from the Legal Ombudsman.
Hi, Sian.
Hello, is it a good time to speak?
Yes, it is, yes.
Oh, brilliant, thank you. So, listen, before I go into any detail, Mr. Hussain, I'll just go and do some security questions with you, if that's okay.
Can I just ask, why do you need to do the security questions when you're ringing me up on my number?
It's just our process that we follow.
Well, that's fair enough. I mean, it's not an issue. It's just that there is no issue of security if you're ringing me up.
Yeah, no, I appreciate what you say. It's just a process that we have to follow, I'm sorry.
Yeah, no, that's fine. I mean, I don't have an issue, but the processes are designed for a purpose. For example, if I'm ringing you up, you don't know who I am, so you can go through security. But if you're ringing me up, you know exactly who I am. But yes, we'll go through the security, but I would suggest that you look to amend your processes because it's not necessary. But we can go through security because that's presently in place.
Thank you very much. So just confirm your full name.
Mr. Sajjad Hussain.
The solicitors at the complaints again.
Burke Niazi Solicitors.
Thank you. And your email address.
fatahbegum@gmail.com.
Thank you so much. And just a reminder, as you're aware, our calls are recorded, but they're just mainly for feedback and quality purposes, okay? So what we'll do is the firm have come back in regards to, so there were 5 other premature complaints that we put forward.
I'm sorry, Shan, to interrupt you, but you said the call is being recorded for training and quality purposes. Just before we move on from that, can I just ask how long are the calls retained for?
If I'm honest, I'm not too sure. I'll have to get that exact date for you, but I can ask our data protection team and get back to you on that.
I just want to make you aware that once this investigation is completed with, I don't know if I think I did mention it before, that I will be making a subject access request and would be requesting a copy of these call recordings just for your reference purposes. Did I make you aware of this?
Vaguely, I think obviously we've had a lot of conversations, discussed a lot of topics.
Yes.
That does ring a bell, yeah.
Yeah, so obviously I just wanted to know if there's because obviously some organizations have a time limit of 1 month. Others, hold for various purposes. So if you can just kindly familiarize yourself with how long the call recording retention policy is, and in our particular circumstances, if it is under like a specific period of time, can you ensure the fact that the calls are not deleted or in line with your call retention policy if it's like a less time period? Because obviously that will give me an opportunity to get a copy of my call recordings with yourself.
Yeah, of course. I'll speak to our data protection team and get that information, and I'll get that back to you as soon as possible.
Okay, that's fair enough. So yes, we were waiting for the reply from. Can you just remind me, when was the last time we spoke?
I'll have to double check the date for you a second, Mr. Hussain.
Yeah, sure.
But it was, so there was 2 lots of premature complaints put to the firm. So previously when we spoke, we discussed, I think it was 3 of the complaints that the firm had responded to. And obviously they had an additional, 8 weeks to answer the other 5 complaints. It's 5 responses that they've come back to. I'll go through each point. Just bear with me, let me check. I believe it was the 14th of March that we last spoke. So that was in response to the first 3 premature complaints, and now we're confirming what the firm had discussed with the additional 5 complaints. So there was 8 premature complaints in total.
Okay,
and obviously I'll go back over the title of each one of them,
yes,
and obviously what the firm said.
Yeah, sure. And the last time we left it, you told me, we had arranged for the 10th of April, but unfortunately 10th of April was a bank holiday. So can I just ask, what date did they get back to you?
It was during the bank holidays, during that time frame. So obviously I was at the office, not in the office. So yesterday was my first day back in the office.
I see. Okay. Because you did send me an email at the end of March, I believe, stating that, you did send me, I think the last time you communicated with me was by email at the end of March.
Yes, so they will arrange a time.
Yes, and you indicated at that stage that they had not, that they were still intending to, respond to the further complaints. I just wanted to know what date did they respond by? Did they respond before the 10th?
I'll have to double check the exact date of their email. I'll have to go through my Outlook, Mr. Hussain, but I can let you know.
Yeah, sure.
Like I said, it's a case of I was back in the office yesterday, and
I
obviously
see.
we've arranged a call for today.
Yes.
We'll go we'll go through each point. So I'll remind you what the complaint head was, which
Okay.
I'm sure you're probably familiar with, and what the firms advised me. So today's really about going through. If you feel that the answers are satisfactory, then it's a case of you have to let me know if you don't want to take this complaint forward, and we'll not include them in with the list of the other 13. If we feel that their answers aren't satisfactory and that in fact you actually have evidence to prove that this wasn't the case of what they're saying, then obviously we'll take that forward and add that along with the other complaints, and obviously I'll discuss at the end just to confirm, what the next stage of the process is.
Okay.
So the first complaint out of the 5 that they've looked at is that the firm didn't respond to your telephone calls and messages that you left with the reception between the start of October and the 8th of December 2021.
Okay.
So the firm have come back to advise that they dispute this, that they have records show that you'd left 2 messages with reception between the time of the 10th of November and the 3rd of December, and that they responded to you via email and within a timely manner. So in terms of, obviously, if we were to take that complaint forward, I'd be asking the firm to kind of provide me evidence that, how they responded to you, did they respond to you within a reasonable time?
Okay. Well, obviously, I contest that. But like as you can appreciate, Sian, it's been some time, so I don't have all the data in front of me. But I'm fully aware that in the month of did I also complain that in the month of December I left loads of other messages that they didn't respond to?
Yes, I believe that was part of your other complaint.
Okay. I think what I'll do is that if you can just go through all the 5, and then I'll come back to and tell you which I'm satisfied with and which I'm not. Is that okay?
Yeah, absolutely. Yeah, and I can take notes. Then, not a problem. So
okay.
The second complaint that they've responded to was that the firm did not share any cost information with you and did not give you any final cost invoices. So the firm have come back and said that they received a representation order from legal aid. Again, I'm going to tell you, they've shared some specific dates with me, so apologies if obviously this doesn't immediately ring a bell, because it has been some time, so you don't have the dates in front of you.
Okay.
But they've said that the representation order from legal aid was sent on the 13th of May regarding the committal matter. The substantive certificate was sent on the 1st of June 2021, but they're not sure when the legal aid would have sent you this, but they're sure that they did. They gave advice on the 24th of June 2021 regarding costs. Following the judge confirming that an assessment would need to take place for the litigation capacity on the 5th of July, a legal aid certificate was issued, and then once a litigation friend was established, all information would have been provided to that litigation friend.
Okay, can you go to the next one?
Absolutely. So the third complaint was that the firm did not inform you that that there was a court order issued in March 2022 to conclude the case, and did not share this information with you until June 2022. So if these all ringing bells, are these questions we put forward? So they've responded to say that the order was received from the court on the 4th of March 2022, similar to what you said. The fee earner contacted you on the 4th of March to say that the order had been issued, and explained that sealed copies would subsequently be provided by the court, and that you responded on the same day, on the 4th of March, to confirm receipt of their email.
Okay, so they're stating that the order was received by them on the 4th, or was it issued out on the 4th?
It was issued out on the 4th, and that they made you aware of it on the 4th of March.
And I responded on the 4th.
You confirmed receipt, so you responded to their email of that date. So they said that you confirmed receipt of their email and responded to them. So obviously the complaint was that the firm did not inform you that there was a court order issued on the March 2002 until June time. But what they've disputed that and said, well, actually, we let him know on the 4th of March, and then he responded to our email to confirm that.
Okay, all right, fair enough.
The fourth complaint was that you asked the firm in March 2022 why the hearing from the 1st of October 2021 was not published in the news, and which as you expected, and that they didn't respond to this until June 2022. So the firm have come back to say that they don't have any record of contacts regarding you raising any questions about why the case wasn't published in the news. And then obviously they've just said that they've kind of given a bit of an explanation as to why it potentially wasn't published in the news, but not something I'd look into. But they've said that whilst the case may have caught the eye of the press, Mr. Hussain would have been aware that court protection proceedings were subject to reporting restrictions and machination, which would have prohibited the press. So again, I'm personally not going to look into the reason why it wasn't published in the news, but it's about the communication of you said you asked
Yes.
them and they didn't respond to you till June. So they've said that they don't have any record of that question.
Okay.
So in regards to investigating, that'd be a case of you just providing evidence that you asked the question. If I got a response from them, then yeah.
So can you tell me the fifth one?
And the fifth one we put forward was that you asked the firm to provide a written response regarding questions why your mother lacked litigation advice. Lacked litigation, and you asked for advice on that, but the firm did not provide you with any. So they didn't respond to your request for advice.
Didn't? Yeah.
So they've come back.
Yeah. Sorry.
No. Sorry. So go on.
I asked for written advice. Yes.
Yeah, written response.
Yes.
Yeah.
Okay.
And they said, you've asked the firm to provide written response regarding your question about why your mother lacked litigation, but the firm did not do this. So the firm has come back and said that they don't agree with that. That you did instruct them for advice on possibility on an appeal against the orders made by the court in February 2021, and that they provided written advice on the 28th of May 2021. And then they've said that it was further discussed in an email on the 23rd of June. So again, when it comes to evidence, I'll request that to see a copy of all that from them.
Okay, all right. So so basically, in total, there's 8 further complaints that are put in, and originally there were how many? 12?
Yes, correct.
Okay, so with regards to the 5, the additional 5, they've basically refuted all they've refuted all my complaints. The additional 5, yes.
Yes.
Okay.
That's what they've responded
yes,
with.
and previously the previous 3, they've also refuted them as well.
Yes.
And previous to that, the 12 originally that I put in, they've refuted them. So in total, there's 8 plus 12, 20 complaints that I've put in, and they've refuted all of them.
That's my understanding when I've discussed them with them, yeah.
Okay, all right. So obviously so if you can just kindly go through you've gone through them all. So can you just ask me what respond to each one of them, because obviously I wanted to make sure that I'm not repeating myself. So can you just go on. So
yeah, of course. Well, we'll just quickly go back through them then.
Yeah.
So obviously the first complaint was that they didn't respond to your telephone calls and messages that you'd left with the reception between the start of October to the 8th of December. So their response was that they dispute that. There were 2 messages left with reception that they responded to them both within a timely manner.
Okay, all right. So in relation to this, obviously I contest this now. In regards to evidence, give me 1 second. I'm just gonna load up my system to see if I can what evidence I do have. If you just bear with me for 1 second.
Yeah, of course. Absolutely.
Just 1 second. Because obviously I will then need to provide you with evidence that these are the calls that were made and these that were not responded to. Yes, here we go. So, if I could just give me 1 second.
I mean, they have come back to say that on their logs that you did make 2 calls to reception. They've agreed that you did make calls. So that was on the 10th of November and the 3rd of December. So this is all 2021.
Yes.
So they've agreed that there was 2 calls and 2 messages left on those days.
Okay, all right.
They dispute that they were responded to.
Okay, well.
If you feel that you made more, obviously, if you said that you've actually made a lot more than
yes,
the 2,
I did.
then obviously that'd be something that you. Yeah.
Yes, it's something that I can evidence. I mean, can you just remind me of the dates again in October?
Yeah, we discussed the complaint. You just said October. I don't think you were able to pin a date down. So in the complaint head, we've just said at the start of October to the 8th of December. That's what we confirmed.
Okay, well, So obviously,
it'd be around the start of October.
Okay, well, that's fair enough. I mean, obviously, I've got some data in front of me now, which obviously I will be forwarding to yourself in evidence. But I've got the called reception at 8th of November, 9th of November, 11th of November, and 22nd of November, 23rd of November, 24th of November, 26th of November, 26th and 29th of November, 3rd of December, and 6th of 3rd of December and 9th of December. So, I mean, obviously, I've got evidence of the fact that I've been ringing up, so I can contest. I feel confident that I can evidence and prove to yourself that there were not just 2 calls between that time period of October to December. There were, multiple experiences, but it's just a cut-off date of the 5th of December that you said, because there were numerous, towards Christmas time, I was desperately, urgently trying to contact them, so I was leaving them numerous messages, and then, as you can appreciate, towards Christmas time, everything stopped. So, just to clarify, I just wanted to be clear on this, that in December, I left numerous messages, like on the 14th, 15th, 16th, 20th, 21, 22. So up to the 22nd of December, there's evidence that I've left numerous messages. So I think the only thing that caught me out in that question was that you put a cutoff date of the 5th of December, when the ideal cutoff date should have been the 5th of January. But it doesn't matter. I mean, irrespective, what they're saying is that basically there was only 2 calls to reception that were answered. Is that correct?
Their response was that on their record, they've only got 2 messages that were left by you on the 10th of November and the 3rd of December, that they responded to both of them. So again, if you're saying that I rang up and left a lot more messages, and I rang up to speak to somebody, and obviously, like I said, you've got it in front of you, you've got the log, they'll be the kind of things that I'll request for in the evidence request.
Okay,
so
not a problem.
Obviously, you've disputed what they've said, so we'll take that complaint forward then, is that right?
Okay. Can I just ask, what 2 dates did they say again?
They said the 2 dates that there was messages left with reception was the 10th of November and the 3rd of December. So that's 2021, that.
10th of... Can you just bear with me for a second?
Sorry.
So
of course.
They're saying the 10th of November. I don't have...
10th of November?
Yeah, 2021. I don't actually have a record of this 10th of November. I've got 9th of November and 11th of November. But I don't have the 10th of November on my records. I've got 8th of November, 9th of November, and 11th of November. And they're saying that they got records for the 10th of November. Is that correct?
Yes, that's the date that they've advanced. And they also said the 3rd of December.
3rd of December. Just 1 second. Yes, I've got... So on the 3rd of December was when I booked an appointment. All right, so so they had responded to that. So are they saying that on the 10th of November and the 3rd of December that I had rang in and they had responded? Is that what the argument is?
Yeah, they said that there was a message left on the 10th of November and they responded to it, and again on the 3rd of December they responded to it.
Okay. So
again, when it comes to the next stage, again, all our decisions are based on evidence. It'll be a case of they'll have to prove to me.
Yes.
I won't listen to the calls, but I just need to see an accurate attendance note or a copy of the messages left. And again, you'll provide me a copy of the call, so then I can compare them then and look at that.
Yes, that's fair enough.
But
So yes,
I'll note that we're taking that forward then with the other complaints.
Yes.
Okay.
Yes.
So the second complaint was that the firm didn't share any cost information and did not give you a final cost invoice. So just to remind you, their response was that they received a representation order from Legal Aid on the 13th of May regarding the committal matters. There was a substantive certificate that was sent on the 1st of June. They're not sure when Legal Aid sent you a copy of this, but it is processed that they would send you a copy. They gave advice on the cost on the 24th of June. The judge confirmed assessment of litigation capacity, so this is when he said that there needed to be an assessment of your litigation capacity on the 5th of July, and that a further legal aid certificate was issued, and that once litigation of friend was established, all the information would have been sent directly to that official solicitor.
So, but irrespective, I mean, if I mean, obviously, I contest the fact that, oh yes, there was certificates, but basically they're saying they did not provide me with that information, did they? The agency provide the legal aid agency. They're basically relying upon the fact that the legal aid agency would have contacted me and provided me with that information, and that is correct. They did. The legal aid agency did provide me with upfront costs, but the question I had asked was that when after you finish a case, remember when I rang them up in 2022, we had a conversation, and I was asking about the costs, like a breakdown of the costs, which they would have necessarily, they were in communication with me, and they said that we are at this stage have not summarized our costs. So I don't accept their argument, because I'm entitled to know a breakdown of the costs. They reliant upon what my entitlement was for legal aid. That's got nothing to do with their breakdown of costs, because obviously that's something I wanted to know about, the breakdown of the costs of what they've charged for. So I don't accept that, like they provided me with that. They can't evidence that. They're now relying upon that. It would have been forwarded to like the other party, but irrespective, for example, if they didn't speak to me in 2022, that's fair enough. But I specifically asked for a cost breakdown, and they said that they couldn't give a cost breakdown when I spoke to them in March, that's still ongoing. So they cannot then now rely upon that. Oh, we did have at the time when we spoke to Mr. Hussain in March, we didn't actually prepare the cost breakdown or the invoice, and then subsequently when we did prepare it, we submitted it to the official solicitors, because they had assured me that they would. I had requested that from them. They didn't provide me with that request, so I would like that to be investigated. Exactly what happened there.
Yeah, and in terms of what I'll do to investigate this complaint, it'll be a case of seeing copies of any communication where costs are mentioned. Again, I'll ask you for communications where you've asked for costs, especially towards the end of the service. And it's all about when you initially take up a service with a service provider, they'll issue a client care letter at the start of the service, so a promise of what their services will be. And in that service, they'll explain how they will give you cost information.
Yes.
Now, I'm then going to expect the firm to issue you the cost information exactly how they've promised that they were going to do at the start of the service. So I'll ask for a copy of the client care letter from them, and if I see that they're not sharing the information or haven't given you any cost information on how they've promised, obviously the time after you've been assigned the litigation friend, then that is different. But there was a time period when they were dealing with you, so before July, I would have expected them to have given you cost information exactly how they would have promised in the in your client care letter. So it'll just be a case of that is where I will request the evidence.
Okay, well, irrespective, I mean, the reality is that, obviously, as you can appreciate, there's a complication because the service was effectively overtaken by somebody else that I never agreed to. But then, obviously, they continued to engage with me in 2022. But coming back to the cost issue, it was very pertinent to me because I did raise this. As you can appreciate, costs are not calculated on an ongoing basis. They're calculated when a case is finalized. Hence why, when the case had ended in January, they've waited until June to put the cost invoice in. It would have been unfair for them or for me to, ask for a cost breakdown while the case was ongoing, especially when there was so many other outstanding issues. But the question of costs were, I clearly had this discussion with Mr. Barrett regarding costs, because I wanted to know how much he's paying. Because the cost was an important aspect of the service that they would be providing me with, because I wanted to know, because he himself, Mr. Barrett, had stated that, we don't get much money from legal aid, and so obviously I knew how much money they were getting. I asked him, how much money are you paying for the barrister, and we had this quite a lengthy conversation regarding costs. So it would have been important for me to understand, to get a cost invoice that they had prepared, and there's nothing wrong with them. You can understand that while, if, for example, if the case had continued and I was still legally represented by the official solicitor, that would have been okay. But all that ended in January. So obviously, when I've spoken to them in January 22 or onwards, I've asked for this information and they've not failed to provide it with me. So I don't accept that, because the reality was that they hadn't prepared the cost invoices in 2021, but they had prepared them in 2022, and I feel that irrespective of the technicalities, they were they were under they had at least a discretionary duty to make me aware of the costs. Because alternatively, it just seems the fact that the steps and measures that they've taken, effectively challenging my litigation capacity and then getting the official solicitors involved, is to circumvent information being provided to me. So I don't accept that, and I would like to be that to be looked into.
And when I make the evidence request, what we do is on each complaint, when we say, what can you provide us, what can they provide us, I'll write a short paragraph on each complaint about how I'll investigate the complaint, what I look at, etc. So yeah, that's up to us. So we'll take that forward. The third complaint was that the firm did not inform you that there was a court order issued in March 2022 to conclude the case, and did not share this information with you till June 2022. But the firm have said, well, actually, one of our solicitors sent in the information on the 4th of March to confirm that a court order had been issued, and that the court would send a sealed copy, would subsequently be provided by the court, and that you responded the same day to acknowledge their email.
Okay, well, like I said, I mean, I think the purpose of my complaint was the last time there was did we not also mention, was there not issue or mention about, did I not complain about the fact that they had submitted regarding the orders in January? Is that another complaint? Because I'm sorry, I'm just getting slightly confused, because one of the issues was that throughout their case handling, they had not submitted any application to the court. However, they had submitted an application to the court in January for the January orders, all right, without consulting me. Was that not?
One of your other premature complaints was that the firm did not make you aware that there was a hearing in January 2022 and what they intended to discuss.
Yeah, and also the fact that they had put in an application, but moving on from this, just to focus in on, obviously there's been the orders that I'm aware of while the case was alive or while my mum was alive was obviously on the 10th of January that I received some court orders. And I've raised that as a premature complaint as well. But then subsequently, all of a sudden, they didn't make me aware from January until March that there was an order. Like I think the complaint, if I can remember correctly, was that from January, after my mum's passed away, all of a sudden they pulled out an order saying that this is an order. So orders don't just come about like willy-nilly. There would have been communication between the solicitor's firm and the courts for them to issue out an order. Like for example, even if they just popped out an order, they didn't. I was not fully informed of what the next process was, because I did speak to them. I tried to speak to them throughout February, but irrespective, I mean, if they just, like I said, I don't have the evidence in front of me whether I responded to that. But I think my complaint was that they hadn't informed me, or like who made the application to get that order. The orders not just pop out from willy-nilly, and from the information that you provided me with. Obviously, I'm gonna have to review this myself, but it just seems quite odd.
Yeah.
It just seems kind of odd to me that the day that the courts issued out the order, the solicitor firms have received it and then bounced it forward to me on the same day, and then I've responded on the same day acknowledging that I've received the court order. That would not be a basis of a complaint, would it? The complaint would have been the response. Like I said, I'm gonna have to look into this, but it was the complaint was surrounding. Nobody's made me aware of an application to the courts. Like, did they make an application for a final order to be sent out on the 3rd of March, or how did that come about? I think that was what my complaint was. I was not informed. It was just basically, we've just got this order now, out of the blue. I think that was more of my issue, rather than what did they do in order to have that order brought about and what information did they provide me with, right, to that order was going to be sent to me. And secondly, if they had sent me the order, was there a follow-up conversation? I would have asked all these questions then, like how did this all come about, how, you know, like, where does this leave me and stuff. So like I said, I'm going to have to review my emails as well to see if that is correct, that I responded on the same day. But I don't think that was my complaint. My complaint was that all of a sudden, out of the blue, they've not informed me of this order. And ideally, after my mum's passed away in January, it was incumbent upon them to write back to the courts or inform me that, look, now that your mum's passed away, this is the situation, and you know, this is where the court proceedings are. They did not inform me of any of this stuff, I think. But like I said, I contest that, and I would like that to be fully further looked into.
Okay, yeah. So the fourth complaint is that you asked the firm in March 2022 why the hearing from the 1st of October 2021 was not published in the news as you expected, and they did not respond to this until June 2022. So you said that you asked the question in the March, but you didn't receive a response until June 2022. So obviously the complaint there is why did it take so long for them to get back to you?
Well,
obviously the
sorry to interrupt you. I know I know how they responded, but my answer to that is that I was not about the. I think there's some things convoluted here. It was not simply about the publication, because I did ask why did the hearing of the October not be publicized, but more importantly, that there was no indication of when the next hearing was. So I think we had this discussion last time, is that you know, at the court hearing on the was it the 1st of October or the 5th of October when I had attended, you know, there was no indication of the next hearing taking place in January. All right, and so that was what I had asked, is that, you know, obviously I attended the hearing. I obviously got no further information. Subsequently from that hearing, attempts were being made to get the official solicitor involved. So the hearing, if you remember, in January was listed. There was a listing for the 12th of January. However, a court hearing took place on the 10th of January. But all these dates and a court order was subsequently issued regarding a booster vaccinations being given to my mum. But can you understand that if I had been informed, because in court at the start of October, nobody discussed when the next hearing was going to take place, because the judge simply vacated the hearing when I challenged him about fraud taking place. So at that point, nobody knew when the next hearing was, and obviously I was not informed about the next hearing. So it was an aspect of why was I not informed, irrespective of whether I was or the official solicitor was involved or not, when the next hearing was. And also I had asked why subsequently that, you know, that it was not publicized as well. So I think there's a convolution of two different arguments there. One is simply the publication, which I then questioned Mr. Barrett on, who then did forward that on to me. So I would not be looking to challenge that, because there was a delay in the publication of the hearing. But that's not the firm's fault, is it? They're not the one that publicize hearings. And that was not the complaint that I lodged with them. I had just simply asked that, you know, it seems very, I need to know when it's been publicized, and the firms did write back to me in an email and tell me that, look, so they did inform me of the publication. So the firm has no liability there, and they're not responsible for publicizing the hearings. So when I asked them so basically I had asked these questions when I spoke to Mr. Barrett in December. He had failed to provide me with that information. And then when I spoke to him in February or March, when I spoke to him next, I asked him the same question again. And then he said, I'll look into it and get back to me. And he did provide me with that information. But like I said, he did not get back to me in December with that information. But that was all to do with the publication and his failure to provide me with that information when I had asked for it. Because I had initially asked for it in December in our telephone conversation that, look, if a hearing took place, how come it's not been publicized? And he said, I don't know, I'll have to look into that. When I spoke to him again in March, I said, look, did you look into it? He said, well, I'm still looking into it again. And then he did respond. But the more pertinent question was not to regard to doing publication of hearings, because that is not basically negligent on the part of the solicitor's firm, because the only negligent aspect would have been when I asked them the question in December, they did not provide me with that information in a timely manner. But the more important and pertinent question was that it was important for me to know when the next hearing were going to be. That at least information should have been provided to me. So there's some convolution there. So I don't really accept their response to that, and I would like that to be, I've provided some further clarity, and I would like that matter to be further looked into.
Okay, that's it. So just to clarify then, Mr. Stain, so the complaint we did confirm, and obviously I sent this in writing to you as well, was that you asked the firm in March 22 why the hearing from the 1st of October was not published in the news as you expected, and that they did not respond to you until June 2022. So that was the complaint we put to the firm. That's what they've responded to, and that's what we agreed on. So is that, do you want to take that complaint forward? You dispute that they didn't share that, they didn't respond to you, because the firm have come back saying they've got no record of you asking the firm that question.
I see. Okay, all right. So obviously I can evidence the fact that I first asked for that information in December, and I repeated myself in March, and then then obviously even if it was asked in March, then why did they delay until June time?
That's the commitment. So we take that forward, okay?
Yeah, so I mean, the aspect is that if it was been publicized, I initially asked the question, because as you can appreciate, this was a hearing in October, all right? It would have, and I asked the questions in December initially. I repeated myself in March, and they had supplied me with that information in June. How is that reasonable or acceptable?
Yeah. And that's what we'll look at. So again, I'll ask. I mean, like I said, they've come back to say that they don't have no record of they don't have a record of the questions that you've asked. Obviously, you provide me that,
yeah,
and then I can go back to them. That's how I'll look at that.
Okay.
Complaint. So the last one was that you asked the firm to provide a written response regarding your question about your mother's why your mother lacked litigation capacity, but the firm did not do this. So you asked for a written response for advice, and the firm didn't provide it. They didn't provide you a written response. So obviously, they disputed it. The firm has said that yes, you did request advice on the you requested advice on the possibility of an appeal against the orders made by the court in February 2021, and written advice was provided on the 28th of May.
Well, you asked. I'm asking like. The question that was put to them was that I asked for written advice regarding various matters, one of which was like, when was my mother's... There was questions asked, not just that simple question, because they're not answering the question that I put to them. They're answering something else, that, I had asked for advice regarding appeal and this and the other. Of course, those were formal advices that I asked for. And like I said, everything is evidential based. We have evidence of this. I had asked written questions to them, numerous written questions, and one of those questions was, can you please confirm to me in writing when my mother was established as lacking litigation capacity? And that was a question, and obviously, if you look at the email exchanges, there was numerous questions that were being asked, not just that particular question. Written questions were being asked and not being responded to, and that was just one of the questions. And so obviously, I had written out those questions. Of one of which was, when was my mother lacking litigation capacity, all right, in addition to other questions that I wanted written responses to. So I think this particular complaint was that the written questions were being asked, and written questions were being asked for written advice, and written advice was not given to me. And then subsequently, obviously, one of the questions what I was eager to understand was, like regarding when was it established that my mum lacked capacity. And in one of the conversations that I had with Mr. Barra, he had told me in passing, I think it was established at the final hearing and stuff. So it was in passing. When the what needs to be investigated here is, had I asked written questions, all right, which required written responses to, and the answer is no. They did not provide me with any written response to this question. They're now saying that we provided advice on a right to appeal, but that's not. You're answering a question That was not asked of you. I did not. The question was not, Mr. Hussain had asked for written advice on his right to appeal, and you had not responded to that. And they're saying, yes, we did. The arguments that they're making are, obviously it's evident to me from the way they're responding and the way that they're handling themselves. I mean, so obviously negative inferences are being made in the manner that I've put 20 complaints forward to them, and not one of them is being upheld. And obviously they're relying on answering questions that were not asked of them. The question was simply this: it is evidentially based that written questions were asked of them. They then need to provide a written it needs to be evidentially based that they provided written responses to them. That can be looked into and investigated, because like I said, I can't go through the numerous emails that I've gone through engaging with them. There was a period of time when I realized that they're not responding, and I'm asking them written questions, and it was just basically they were not even responding to them. So when I've asked a written question, or when I've asked a question once, right, they've not responded, then it takes me a second or a third time to get that clarity, and it's just basically off the cuff remarks like, oh yeah, we just give me something after the event. So no, I don't accept the fact that they answered that in writing. Are they stating that they provide me with written advice?
That's what they said, that they provided written advice on the 28th of May. So again, when it comes to me investigating this complaint, I'll ask for a copy of obviously where you've asked for the question, where you've asked for their written advice regarding that specific thing about your mother's litigation capacity, and I'll ask them to see a copy of the firm's response. I agree with you. If you've asked them a specific question and they come back and say, well, actually we answered X, Y, and Z, but we didn't answer the question that he asked us, then that's going to be a reasonable service. If you've asked a question, I would expect to see them at least acknowledge it.
Yes.
Or answer it. So I agree. So we'll take that forward.
Okay.
Then. So we'll put down. I'll obviously put down. We'll add those 5 complaints onto. In total, it's 20 complaints. So what I'll look to do, Mr. Sane, is I'll look to get what we call an evidence of standards letter out to you and to the firm. Again, each complaint will have a little paragraph to explain exactly how I'll look into the complaint, how what I think is a reasonable service. So I'm setting a standard of how I'm going to investigate and what I'm expecting to see if it's a reasonable service. And then I'll ask evidence of yourself, evidence of the firm, and then obviously normally we say, can you get back to us within a week? But in this case, there are 20 complaints, so obviously you're going to need a little bit more time to kind of dig around and get that evidence together for me. So we can discuss a suitable date as to when you think you can respond back to evidence requests, because I appreciate it's a big complaint.
Well, no.
But I'll look to get...
Okay, well, sorry, I understand this. So the next stage is evidence-based. But look, I'm not going to be providing you with evidence that they already have. That would be like defeating the point, because if I can just come back to the step where I've asked for full disclosure of the records that they've had, you've sent me an email saying, oh, well, no, he's got a copy of them, all right? He's already got a copy of them. I'm going to say, no, I don't have a copy of anything. My email server went down. I've got no emails now. All right, so I'm not going to be providing any email communication. So that's the first point. I just wanted to address the aspect of the email that you sent me with regards to when we last spoke. I was saying provide me with full disclosure under the of my case file. All right, so basically they're saying, well, he's already got all that information already. So that's the argument. I don't accept that, because evidently they've got call notes. So, like, for example, they've already mentioned that, we've got notes that Mr. Hussain rang up at this particular time. And so, but that's, so can you understand? They've got documentary evidence that Mr. Hussain rang up and left a message at reception. Those are not being provided to me. I would not have a copy of that, would I? Unless I made my own notes, which I did do. But the reality is that they've already got that information. They're not providing me with that information, and I believe I'm entitled to that information. Now, with regards to taking this matter to the information, like you've advised me previously that, obviously it's not something that you'll be looking into, because that's something that the Information Commissioner's Office handles. Now, in relation to the Information Commissioner's Office, in this particular regard, I need to make you aware that the Information Commissioner's Office have advised me and told me that it is not their policy to prosecute people. They don't take that approach. They're more like an advisory service. So the fact that the Burke Niazi solicitors have failed to disclose my records to me, my only next option is to take litigation action against them for failure to disclose this information. It's got nothing to do with the Information Commissioner's Office. I've had a lot of dealings with the Information Commissioner's Office, and it seems to me that even though they are a regulatory body and do have regulatory powers for penalising failures, the position taken by the Information Commissioner is this, that they would rather be an advisory service. And so if they do find that breaches of the data protection have occurred, they often more than likely do not prosecute data breaches or failures on SAR requests. What they often do is they just politely advise the services. So in relation to this matter, I've had it looked into by the ICO. I mean, obviously I'm contesting what those are outside the scope of your investigation, but I just need to make you aware that just the ICO will not prosecute or take any penaltative actions against Burke Niazi solicitors, because they have to be satisfied that numerous other people's complaints have been upheld with them regarding, for example, Burke Niazi solicitors, before they even consider taking any kind of action against them. All they as you can appreciate, Sian, is that there's a cost involved, and nobody wants to take a litigation action if there's a potential for failure, and that's the same position that the ICO take. But irrespective, at this stage, with regards to evidence-based, there is evidence. The evidence that you require is with Burke Niazi solicitors. All my email exchanges, everything is in writing. So I don't think I'm in a position to provide you with any evidence in this regard. However, what both Burke Niazi solicitors do not have, and which obviously you would not be able to source from an alternative mean, is my own records, which are outside of, like, my call recordings of the conversations we had, which obviously I've catalogued. So I'm happy to provide you with that, so you can, for example, see in evidence that on this occasion we had this conversation. Like I said, I've read out to you the calls to reception, which I have recorded. Now ordinarily, my means of evidential based is or recording based. So that would be information that Burke Niazi would not be able to provide you with. I do not believe that Burke Niazi recorded the calls, so that would not be some evidence that they can rely upon. I don't believe, because as you can appreciate, in the start of this conversation, you've made me aware that this call is being recorded. All organizations, particularly solicitors firms, have to make me aware as a consumer that the call is being recorded. So I don't believe that they have ever made me aware that the call is being recorded. So anytime that we've had a telephone conversation, the only thing that they could have made is notes on the call. Just like, for example, you may look to make notes on this call. So the evidence that they can be reliant upon is that on this particular day, we had a telephone attendance and a written up telephone attendance notes, which, by the way, have not been provided to me, and I don't have a copy of that, and that's what I requested from them. But they can then present you with telephone attendance notes. The only thing with that, Mr. Sian, is this, that things can be fabricated. All right, after the events, there's nothing stopping them fabricating something. However, so the evidence that I will be relying upon is my call recordings with them, because I did catalogue all my call recordings as evidence, which you would not be otherwise privy to. And particularly in relation to, like, for example, like my communications and questions I put to them, that was done orally over the telephone. Now, if they chose not to write that down, that's a failure on their part, isn't it? And they cannot then state that, oh, he never said those things. So, for example, in December, I had asked for, information regarding the publication of the hearings in October. Now, if the only evidence of me asking that ordinarily would have been the attendance notes that would have been written up by the solicitors themselves, and therefore it's all in their domain. However, under these circumstances, I know I said those things because I recorded them. So the evidence that I've collated, I don't think I need a week, because I will not be providing, for example, email exchanges, because those email exchanges are available to you from the solicitor. They have a copy of those things. The only things that the solicitor do not have in evidence is my call recordings, which I'm happy to provide you with. The only thing I don't have from them, in addition to like email exchanges, is I don't have the attendance notes, which they are required to provide me with, which they're not being providing me with, which I'm going to take legal action against them for. So in relation, just for your clarity of understanding, if there's an email exchange between me and the solicitors, then it's incumbent upon yourselves to get that information from the solicitors rather than myself, because obviously they're a paid service. I'm a member of the public. I can only provide you with information that evidence that otherwise would not be available to yourself from the solicitor's firm. So for example, when, like in an example earlier on, they're saying that I am saying that I phoned up reception. They're saying that no, he hasn't phoned up reception on all these times. So but they did respond to like on one occasion or two occasions. All right, so they've got attendance notes, so they then have to evidence that there was an attendance note on the telephone.
Yeah.
So but for example, if I've left a voice message for them, they may not have recorded that, and they may not be able in a position to provide you with that information. But I clearly can, because I did go through the extra task of recording this now. So that's what I will be providing you with, and I've already collated this information, and I'm happy to present that to you. If the other firm need more time, then that's fair enough that they can gather that information. But ideally, they should have IT systems in place. But just as a summary, I just want to make it clear my position is this: that from the offset, I knew that they are colluding and conspiring with the local authority, or they were acting malevolently. So I knew that from day one. Hence why I would refuse to, in the past, get a solicitor to represent me. Now, through your findings, you're not going to be able to conclude that, because that's not your scope or remit to have those allegations substantiated. All you can have substantiate is the 20 or so complaints that I've lodged with yourself, and look at the evidence. From my perspective, I'm just providing this extra information to you, is that I have always believed that the services of the Burke Niazi solicitors were privately commissioned out by Bradford Council, and you can see that from my communication exchanges and the conduct and behaviour of them. This is not simply a failure of service, because a failure of service can be rectified in the sense that we all humans, we all make mistakes, and these are just mistakes, or more training can be provided to rectify mistakes. Under these circumstances, you cannot rectify these mistakes, because these mistakes were out of malice and contempt and criminality. You can't ask somebody who's a rapist to not be a rapist by sending them on a training course, upholding the fact that they need to be, obviously they've acted. Basically what I'm trying to state is that they've acted with malicious intent. Malicious intent cannot be rectified by telling somebody, you've acted with malicious intent, don't do that again. That is fundamentally the problem here, is that my position is, and always has been and remained throughout, from approaching them initially from April, from the 1st of April, and I'm just conscious of the fact that we're now in April, a year later in April. No, 2 years later, sorry. But I had contacted them initially in April with the understanding that their services would have been, privately commissioned out through nefarious means. Hence why I had recorded all my conversations, and obviously those are going to be made available to you in evidence of the fact that from initially in April and May, it was evident to me that the services had been commissioned. By June and July time, by July time, they had stopped even talking to me, in line with the local authorities' policy of getting me to write things down and not speaking to me on the telephone. So it's evidential based that I wrote out to them extensively in July and August, at a time when my mum's life was in danger, because the CCG had put in an application to vaccinate my mother. It is my full belief now, at this stage, considering the way and approach that Burke Niazi have subsequently taken from like effectively taking the maximum amount of time through the processes, are not looking to disclose to me the record, that they're acting with malevolence, and there's no resolve of advice if somebody's acting with ill will, contempt, and malevolence, and that's been my position. So I just wanted to highlight that is my reason I'm approaching you, is that that this is a clear act of malevolence that has resulted in my mother's death, because of the fact that Burke Niazi solicitors, although acting and representing myself, effectively try to like sabotage my legal rights, and were effectively working with the local authority and other parties to my detriment throughout this whole process, which has resulted in my mum's death. So I just wanted to leave you with that overview of why I've approached yourself and what my expectations are. Now, moving on from this, I just wanted to ask that, considering that we now have 20 complaints going forward, and you would like, can you just give me like a time frame of when you hope to finalize things? And I know it's not going to be written in stone. So the next step is, obviously, you're asking for evidence. I'm quite happy to provide the evidence by end of play today. I don't think I need further time. How much time are you willing to provide the other party, and then from then on, how long do you anticipate to investigate?
Okay, let me just go back a little bit there, Mr. Tatum. I understand your expectations. It's been really clear all the way through what your expectations is. At the end of this process, it will be a case of whether I find their service reasonable or unreasonable. I cannot make a determination behind the motives.
Yes.
If I find a reasonable service, I cannot establish the reason of that
Yes.
why they've given you a reasonable service.
Yes.
The most I can look at is potentially some compensation for distress and inconvenience. Okay. At the end of this process, that is what we're here to look at.
Yes, I understand.
I'm concerned that, we might not be able to reach your expectations.
Yes.
Because at the end of this, I may find some unreasonable service, all of it reasonable, all of it unreasonable. I don't know until I see the evidence.
Yes.
At this point, I'm still a bit of a blank slate until I get into the evidence and look at it.
Yes.
In terms of a timescale moving forward, so in the next couple of weeks, I'll send you an evidence and standards letter. So what I'll look to do now is create the evidence letter. So I'll go through all our conversations, all my conversations with the service provider. I'll make a list to both of you what I need per complaint. I'll write you a little bit of a paragraph on each complaint as to how I'll look into the complaint and what I think is a reasonable service. So I'll look to get that out to you in the firm the next couple of weeks. It's great that you can respond really quickly. Obviously, we have to allow the firm some time to respond. It fully depends again. If they've got thousands of emails that they need to provide me, I don't think it's reasonable for me to give them a week. I think I need to give them a little bit longer. But at most, we normally say 2 to 3 weeks, unless the firm come back to me and say, well, actually, we've got thousands of pages of evidence we need to provide. Can you allow us a little bit of time? But we're talking a matter of weeks, really, for the evidence to come to us. And then once it's with me, again, if I have thousands of pages of evidence, it's going to take me a lot longer to review it. If the firm only provides me, 100 pages of evidence and you only provide me with call recordings, again, it hopefully won't take me too long, because I really can't give you a time frame. It'll be a couple or a few months at most, hopefully. But again, it all depends on the level of evidence I get back. In some cases, it could be 50 pages, which is much easier to organise, because I have to organise it chronologically and do everything, because when it comes to sharing my case decision with you both, I will provide you both a copy of the evidence I've used that I referenced in my case decision. So I have to organise all that. So again, it totally depends on how much evidence is shared with me. Once I've got that in, then I hopefully should be able to give you a little bit better of a time frame once we're past that point. Because once I know what I'm looking at, then I can schedule my time and let you know realistically what time frames we're looking at. But if you're concerned that it's going to take another year or so, it absolutely won't. It'll be a matter of a couple of months. I'll need to get the evidence in. I'll need to see how much evidence I've got, and then I'll be able to give you a better time frame of how long it'll take me to get through it.
Okay, well, that's fair enough. I mean, so when you make an evidence request, I would like, obviously, I would prefer you to put a week limit on it, and obviously if then that gives the solicitors an opportunity to say, well, actually we won't be able to comply within a week. We require more time, because like I said, I don't require more time. And similarly, the solicitors, if they require another week, that's, I think, reasonable. But the reality is, at this stage, it's not a case of we've got like 1,000 emails and like in a conversation with somebody that's ongoing, that's not been basically audited. They must, by the very definition, have audited those emails. And so, because obviously they've had an opportunity to address those complaints, so ideally in any kind of organizational situation, they would have catalogued all the email exchanges in order to provide you with a response. So they already basically in this particular case, I would just like to provide you with a summary of the time frames involved. So it's between the 1st of April and obviously the last one would have been in June. Most of it was done in the from April to December, or the email exchanges. Obviously the case ended in January, so there wouldn't have been that much email exchanges. So we're not talking about some cases that can go on for years and years, and there's a substantial plethora of communication. And number one, and number two is there was no written i.e. postal letters sent through to each other, which obviously would require a different cataloging of letters versus emails. Everything was done either by email or by the telephone. So there is not like a substantial amount of information for them to collate. And no doubt, as you can appreciate, as a solicitor's firm, if they're sending out one letter, all right, ordinarily, if they're sending out a letter, that letter needs to be costed up, because they're charging for that letter. So the idea that there's a lot of emails and it's going to take us some time to collate them all, it's a very weak argument to make, because every single email that they would have sent, there would have been a cost associated with it, and no doubt they have IT systems in place that would have. So for example, if they wanted all our email exchanges, it's not the case that I used many email accounts or it's complicated. The complexity does not come from 1,000 emails, because all you got to do is do a filter on your inbox and you got 1,000 emails. You understand? And then obviously, if you a press of a button, you can print them all out. So the numbers are not complex. It's not complexity due to numbers. It would obviously be complex if there were 10 different email accounts that I used, that I was communicating them with, and obviously to collate all those different email accounts. Can you understand? That's the level of complexity. But I think, sorry.
I appreciate what you're saying completely. Like I said, I've dealt with a lot of firms in the past, so it will be a case of, I appreciate what you're saying. And my aim is to try and get it moved along as soon as possible for you and the firm to try and settle the matter. So, I'll manage that with the firm. It's our investigation. So we'll manage that with the firm, and, it's up to our discussion to whether we think it's a reasonable request or not. But again, we're not even at that part yet. So I'll have to make the evidence request first and go from there. But it's up to us to manage the firm. If the firm don't comply with us at all, obviously, then we are bound to the SRA. But the firm have engaged so far with all our regulation and policy. So hopefully we can get that, evidence into us as soon as possible. And once that's in, I'll have a better idea of how long it will take me to get through everything. But again, we'll make the evidence request in the first instance and see where we go from there. I'll always keep you up to date and informed, and obviously again with the firm, whatever advice, I'll let you know.
Okay, so can I just ask one last point, is that, obviously they've written out to you. I've not seen this. I've just got what you've told me. And one of the important things I wanted to know is, obviously that's evidence-based, because as far as I'm concerned, I need to evidence what their responses are. So once you receive their evidence, are you able to, while you're investigating this, to provide me with a copy of all the, can I just confirm, have you had are all your communications with the firm in writing, or are they on the telephone as well?
To them over the phone quite a few times, because it is just an easy form of communication, in my opinion.
Yeah, okay, that's fair enough. But am I able to get because obviously I've explained to you, once this case has been completed with, I will be making a request for this disclosure. because obviously, I mean, because I need to know what dates that they responded with. It's not so important for me to know what they responded to me with, because you've already explained that to me. But am I going to be in a position to procure the evidence, or also all the communications that they've had with yourself?
Yeah, I mean, if you want a copy of all the communications, Mrs. Zane, obviously then that would be a data protection request, that you've made to me. But all evidence will be available to you that I've used in regards to my case decision. Because if we get to a case decision, it might be that what will happen is once I've reviewed the evidence, I'll come to my findings on the case and I'll look to discuss them with you on the firm in the first instance. Now, if you both agree with my findings and both agree that, with everything that I've found, then we kind of close your case and we just confirm it over the phone. But if either of you disagree with my findings, you can request a case decision which is in writing. And at that point, I'll provide a copy of all the evidence I've used to come to my decision. So all the evidence I've referenced in my case decision. But if you want a copy of all the communications, etc., then that will be a subject access request.
But the subject access request is not, that would be relating to my communications with you. But your communications with the firm would not be covered under the subject access request, or would they?
Well, again, I'd have to double check with the data protection team. They are the experts, so they'll know exactly what they can and can't share with a third party.
Okay.
I'd be lying if I said that, I understood every single part.
Yes.
That is something we have a data team for. I'd have to check with them all. When you made the request, they would be the better ones to explain it to you. But I will go away and ask the question that you put to me at the start of the call, which is, how long do we hold call recordings for? So I'll go away and ask that question. I'll come back to you as soon as possible.
Okay.
It's unlikely I'll get an answer today, but I'll try and get back to you.
Okay.
Early next week.
The reason that I'm asking these questions is that once you start the investigation, I should have all the information available to me, just as you have. Okay, that's what I would like, because obviously that gives me an opportunity, because basically you're going to have all this information or evidence. I don't have that evidence right now. I have my own evidence, which I'm going to present to you. And obviously the other party can have that evidence, while you're looking into this. But it's because you understand, Sian, at this stage, they've not provided me with anything. They've not provided me directly with my SAR request. They've not provided me with any information. I'm effectively having to speak to them through proxy of yourself. And if they've communicated with you regarding my complaint, I need to know the chronology of time frame of when they contacted you. Like, for example, they were required to present this these answers by the 10th of April. That's what we had agreed to. That's what they had agreed to. But by the end of March, you had written out to me confirming that they are still intending to get back to us, but they haven't done so. So can you understand, from my perspective, that all goes to evidence, to me at least, that this is circumstantial evidence that they're acting with malice and ill intention, because the answers that you...
Timmy, can I just bear with this, they did respond by the deadline. It's a case of I wasn't in the office to share those answers with you until we've arranged a call today. So it's not a case that they've not come back within this policy time, but we agreed, they had up until the 10th of April. It's that there was a bank holiday and then I was on annual leave until yesterday, and then we arranged a call for today. So they did respond before the 10th of April. So
But when?
Responded within...
But when did they respond?
I'll go through and I will go through and let you know. I'll have to go through my correspondence to double check. But again, all I've got in front of me right now is the answers we've discussed. But what I'm saying is that they did respond for the 10th of April. Again, if you want a copy, I can ask the data team in terms of how it works with a third party. And I appreciate what you're saying about the evidence. But right now, the investigation is about what our findings are going to be. I appreciate you want to see a copy of all the evidence. But again, it will all be shared within a case decision, and then if at that stage you find any inconsistencies in their evidence, then you can come back with your comments and dispute the case decision, and then I'd go away and look at it and take comments on board. Again, if you still disagree, then an ombudsman can look at it, but we're not near that stage yet.
I understand.
I've not even made the evidence question.
I understand, Sian, but I understand. I'm sorry to interrupt you there, but the reality is that, let's just say for argument's sake that they did respond by the 10th of April. They could have, and there's no fault upon them, but quite clearly negative inferences are being drawn, because you had informed me by the end of March that they're gonna respond to us. The answers that they provided do not require 8 weeks. The fact that the negative inferences are being drawn that they are deliberately rolling this out as the maximum amount of time available to them. Like, for example, when you make a subject access request, you have 30 calendar days to respond. Now, if you respond after that time frame, then that's a statutory violation. Now, if you respond like exactly on the day, then obviously negative inferences are being drawn that obviously that there's no fault, but clearly a negative inference has been drawn that if I requested some information, some like simple information, like can I get a copy of this call recording, let's just say, and you take the maximum amount of time on one occasion, that's fair enough. But if there's a consistency, there's a pattern of behavior, and all I'm trying to establish for myself and my own satisfaction, that there is a pattern of behavior, and that pattern of behavior is that we're gonna kick this issue kick the can down the road as far as we can, and that is also evidence. Can you understand that if things can be resolved a lot quicker? Yeah.
I absolutely appreciate you saying, especially because you've had the investigation with us, you raised this complaint, a while ago, and we're at this stage. Obviously, I appreciate it. It is frustrating, obviously, for me as well, because I'd like to try and get on the investigation as soon as possible. But what I will say is it's our investigation, so these deadlines that we're setting for them to get back, and they haven't been unreasonable in getting back to me. They have got back within 8 weeks. I appreciate what you're saying that, well, actually, could they not giving these answers sooner than 8 weeks? And I do get that frustration, but it is within all our policies and regulations, and ultimately it's our investigation.
Yes.
So if we have an issue with how the firm is taking time to respond to us, then I will address that directly with the firm. And I appreciate your concerns, what you're saying, but that will be for us to directly address that with the firm if we had negative experience. At this time, I appreciate it was frustrating having to wait for these full 8 weeks for them to give the responses, but that is within our time frames and policies, and they did issue a response to me. Yes, you've disputed it, which is absolutely fine, but they have given responses to the questions. So I've not drawn any negative inferences. We're very much independent and objective to this. So I appreciate you may have drawn negative inferences from your experiences and how long they've taken, and I can fully appreciate those frustrations. I really, really can.
Okay.
But at this time, I have drawn no negative inferences towards them or yourself or anything, completely objective. They've come back to me within the time frames I've asked them to come back to me, and at this point I have no concerns. If I do get concerns down the line, then I will address them directly with the firm. So I don't want if anything came, I'll deal with that directly with the firm.
And Sian, obviously you're perfectly right to do so. Like you said, this is your investigation. It's not my investigation, and you quite rightly, you should not be drawing any negative inferences because of the fact that they're complying with your policies and procedures. But obviously, if I have to take a holistic approach from day one about how the situation's been managed. Now, obviously, I've raised a complaint at each stage. They've taken the maximum amount, and I'm trying to respond as quickly as I can, because as you can appreciate, I've got better things to do with my life. Overall, it's in my best interest for this matter to be expedited and done quickly. Overall, objectively speaking, if they are at fault and they know they're at fault, it's in their best interest not to have this matter expedited as quickly as possible and to take the maximum amount of time. That's just my understanding. The reason I was explaining that to yourself is that irrespective, I cannot evidence that right now. Obviously, I would like to know when the dates that they had responded by and what they've responded with, and I don't think that me having that information should be problematic. So obviously, what I would like you to do is going forward, I would like you to get in touch with your data protection team and ask those two questions. First of all, is the retention time, and make them aware that I will be making a subject access request, and also to ask regarding the scope of what's going to be disclosed, because obviously I would like to, because this is I know you're investigating this, but I'm still the complainant here, and obviously this is all data relating to myself, and I need to know if I will be able to be provided with your communications with the solicitors, and would that be covered under a subject access request, or would that be a different procedure? Because I don't think there's, like, for example, if I'm providing you with evidence, which I will be shortly doing after you make your subject access request, you can ask me do we have permission to forward this onto the solicitors, and or not. and obviously I can say yes, of course. Similarly, I need to know the fact that the evidence that they're going to be presenting to you, if I'm looking to challenge that evidence, or maybe, like, for example, if you make an evidence request, they provide you with that evidence, and like, you're the only one privy to that information, then obviously I can say, well, actually, this is wrong. This has maybe been doctored that they're providing you with. All I'm just trying to say is that once what they've provided you with in communication, or in responses, I would like to have a copy of that, so I can see exactly what their responses is, rather than when you're telling me what they've said, that's classed as hearsay, because effectively you're repeating what somebody else has said. Whereas if I can just see myself what exactly they've said or responded to those, would it be possible for me to get their responses, not your interpretation, but their responses, their direct responses, so I can see exactly how they've worded each of the responses, and the date and time that those responses was received by you? Would I be able to get that information at this stage?
Well, I will go in after data things. I'm already going to go in after, in terms of the call recording, like,
yes,
how long we keep hold of that.
yes.
So I'll go in and ask that question. I will come back to Mr. Sian. Obviously, the chance of me being able to speak to somebody now on
that's fair enough.
is unlikely, but I will speak to somebody. I will come back to you next week, okay?
So
I will let you know as soon as possible.
Okay, so just for you to understand, my perspective is that I also need data and evidence from the firm, all right? And obviously, any communications on this case, either they should have provided me with the case file themselves, they're not choosing to do so. That places me in a better position to take legal action against them. Subsequently, they've been communicating to you regarding the case, and I would like to have that evidence available to me. So if you can kindly look into that, and I'll leave that with yourself. I appreciate that it's not going to be today. Obviously, we're coming towards the end of the day now, and I appreciate that it may take some time, but if I can just leave that with you, and I look forward to your evidence request email when you formulated that and written it up and sent it to me. Hopefully you'll get that to me in the next week or two.
Yeah, that's my aim at this time. Yeah. As soon as I get a response back, I'll go to the data team, and as soon as I get the response back, I'll let you know as soon as possible, Mr. Sian.
Okay, that's right. And you will look to get back to me with the evidence request. And you're going to write it up. Is that going to be next week or the week after, do you think?
Well, I'm hoping to get it to you next week, but it may potentially go into next week, depending on how, going through it and things like that. So okay. I'll have to draft that from scratch, if you will, with the standards. Now I've spoken to you about all the complaints and the firm. I'll look back on our conversations and I'll draft that, but I'll get that out to you both as soon as possible. And again, I'll come back to you as soon as possible regarding the data, information that we've just discussed.
Okay, that's fine. Can I just ask one last question? Is that when was this case opened with yourself?
Let's have a look. Just bear with me. I'll have to go back on my system. Let me have a look. So I think I can tell you the date that you bought it to legal ombudsman. Just bear with me. Let me just go through my systems. So the case you bought to us was on the 19th of August, 2022. So, that's the day we received your complaint to us. And let me just have a look at the first time that I have got the case. Hold me a second. I'm just going through a lot of the communications, obviously. Won't be a moment. I believe the first time that I picked up was December, and the first contact I've had with you was around the 30th of December.
Sorry, the 30th or the 13th?
The 30th.
I've
just had a look at my first communication to you, so...
Yeah, so it was on basically at the end of the year, 30th. So So I raised it. Yeah, I understand. And we've had quite a lot of lengthy conversations in January, and there have been further, preemptive complaints that you've looked into. That's all happened in January and February and March and so on and so forth. So, but just to clarify, the complaint was lodged with yourself on the 19th of August, and then we had first communication on the 30th of December. That's correct?
Yes, that's right.
Yes, I understand. Okay, that's fine, Sian. Have a good weekend, and I look forward to hearing from you. Thank you.
No problem. Thanks very much. Thanks for your time, Mr. Singh. Take care.
Goodbye now.